Hello, thank you for joining us on MIRS TV, where we strive to educate, inform, and question issues regarding foreclosures, banking, and the economy. My name is Janet Reiner, and today is Thursday, May 9th, 2013, and today's guest is Shelley Erickson. Now, Shelley is the owner of Shelley Suntan Parlor and Total Body Works Day Spa. She's been in business for 32 years. And you are a homeowner's advocate,
Yes.
Is that correct? And we are here today because an incident happened to you, which was a little unusual, I thought. This is in regards to a federal bankruptcy judge, Peckman, who is out of King County in the state of Washington. Is that correct?
Yes, I'm not too sure she's just a bankruptcy judge because the issues I had with her weren't in bankruptcy.
Oh, okay, so she's
Right,
just
so
a
she's
federal judge. Oh, yes. She's a federal judge. Okay, well, wonderful. So an incident happened with her. Can you tell about the incident itself?
Yes, I had two federal marshals. I can't even talk. I had two federal marshals that are rather tall, and they came into the building and questioned me on an incident that happened to the judge, and they told me I was one of their main suspects.
What happened to the judge?
Well, she had a party graffiti her sidewalk out in front of her house.
Oh.
And they had gone to the effort to find her home, locate her, and to write graffiti on the sidewalk stating, "How much did they pay you?" And because I've been an advocate against her and been attacking Peckman, Dixon, and Tabor, and mostly Peckman because I have issues with her in two cases of mine, seeing that in my vision that she's a corrupt judge.
And that's just an opinion.
Yeah, that's my opinion. Trying to expose her for what I feel she's done in my cases and many cases. Not saying that she's even ever judged a case on the behalf of a homeowner. That from what I am finding, she's judged for the banks only. And so they questioned me and said I was a prime suspect for doing this graffiti, and yeah, which was rather shocking, but something I still wasn't surprised they came because.
But she's oversaw hundreds of cases during her judgeship. I mean, are they doing this to everybody? Are they questioning everybody, or did they just select you separately?
No, I understand that she has quite a long list, and I'm not surprised about that either. That there are a lot of people that dislike her, but I've been very open on blogs. I've been very open on postings.
Okay.
I've been trying to expose her. I've been pushing for a group of attorneys that actually are circling the wagons around her because they also agree with me, and they're talking about doing a mandamus against her. And so because I've been exposing this on the blogs and internet, they felt that I would be a party to talk to. What they really didn't put two and two together is I'm trying to expose a fight against crime. I'm not trying to be a criminal. I'm trying to fight crime, and I'm not going to commit a crime to fight crime. It doesn't make any sense.
There's an irony there.
Right, exactly. And if they knew my drawing, they wouldn't call it graffiti. Every bit of graffiti I've ever seen, it's kind of artistic, and I'm a stick person, but they definitely said that I was a suspect, and they interrogated me.
I find that very interesting that they targeted you specifically. Out of the hundreds of cases that she oversaw, all the attorneys, all the homeowners, everyone that's even associate, friends, family, members of the homeowners, and they targeted you.
Well, I don't think I'm the only one targeted. Yeah, I've heard of others that were targeted too.
Really? Okay, I just find that very strange. So what was your reaction when this happened?
I wasn't surprised because when it first happened, just looking back on the dates, because I asked them, the federal marshals, because I said, I will email you a copy of what I received over the internet, because they told me I knew too much, and that they were watching my posting, and that I was posting attacking Peckman on the internet, and then all of a sudden I'm not. Well, the reason I quit attacking her is I received an email that had come through a group of attorneys saying a federal Washington, it didn't even say what state, it said a federal judge has had her sidewalk graffitied, and they had in big block print how much did they pay you? And then I shortly afterwards get an email from my attorney telling me to stand back and not to attack Peckman or any federal judges. She actually didn't even mention Peckman. She said not to attack any federal judges. And I'm thinking the reason I got this email is because she knows, she has read my article, my own pro se cases before I hired her, and I have tried to I have based claims of felonies and violations of the 18 USC law 4, 18 USC 4 law, which says that a judge is in the position of and must see fraud and report it, not enable it. And so that's been one of my claims against her. So she knows I've been very outspoken in the courts and on the blogs against her.
Well, if they considered you a suspect because of the information, they considered you having too much information, I find that very unusual, because people like myself, who I interview a lot of people, I talk to a tremendous, my circle and sphere of influence and sphere of people that I talk to is a tremendous sphere. Does that mean that I'm going to get a call? Basically?
It could be.
I guess what I find it very unusual about this is that all of a sudden having too much information is considered questionable. And I find, and it sort of makes me bring to light a question, and that is, just because you have too much information, is that considered a bad thing?
Yeah, I don't know. I don't think they said that I had the right, because I was open with them. I told them that I absolutely dislike Peckman, and I feel that she's very corrupt. And they said you have the right to do that. They wanted to know if I was thought that it was okay to harm a judge. There's no way, to physically harm somebody. It's absolutely, again, illegal. I'm not out to advocate crime. I'm out to advocate against crime.
Right, exactly.
And that's what I feel that she's doing, is enabling crime, and she's blocking the rule of law, and she's doing unconstitutional rulings. And that's the way I attack her, is legally.
Right. And here's the thing that I just sort of question, and that is the fact that because of the fact that we have the situation, it's not just Judge Peckman. This is a situation that's going across the board, across the United States, no matter what state you're in. And part of the issue I have with judges is the fact that since this whole scenario, this landscape is so new, on one hand, they're not quite educated as far as what's going on. I think the attorneys, the foreclosure defense attorneys, are trying to educate the judges, but Judge Peckman is by no means the only judge that homeowners are having an issue with. I think across the United States, there are federal judges, there are state judges, there are lots of judges, district judges, they're all judges in which we're having problems because I personally, this is a personal opinion, I personally don't think that they're aware of the breadth, the scope, and the depth of the issues that are going on with homeowners. What do you think?
I disagree with that. I think that's maybe an excuse used for them. They have to be in a position to be aware of what's going on.
Right. I'm just trying to be a devil's advocate.
Exactly. I think that they feel that a homeowner shouldn't get a free house, and that's not what the homeowners were out to do.
Right.
If homeowners are out for justice, we don't want to give a house free to somebody that doesn't own it.
Right.
We don't feel that the criminals should be getting the houses, and we're more than happy to pay our mortgages, but we don't appreciate having our houses wrongfully stolen and manufactured defaults that we're not guilty of.
Well, so I have a question for you. Getting back to Judge Peckman, are you aware of any decisions that she has made on behalf of the homeowners?
Not one. Not one. And I actually have two cases.
Not one?
Not one. And I'd like to see it. I mean, she's welcome to send in a copy of her cases, and state something that I have missed, but I have not seen one case with her or many of the federal judges. I think it's a crapshoot on which federal judge or any state judge has worked with the homeowners and ruled by the rule of law. And I don't mean work with homeowners because they are biased to homeowners, but that they're going with the rule of law. I see judges that are dismissing cases that are perfectly good cases, and not just mine, because mine was pro se. I admit that I was pro se, and I didn't know a lot about the law at the time. I know a lot more now, but I'm seeing very good professional attorneys submitting cases that are dismissed for no good reason.
Well, isn't there statistics from the banks that say that 30% of the documentation that's done by the banks where 30% of those cases were wrongful to begin with? This is an admission from the banks,
exactly.
right?
The banks are admitting that they have wrongfully foreclosed on 30% of the homeowners out of 4.6 million, and I believe it's probably greater because they're only talking on this list that that we have on to go on a screen. That is the list for only the people that are within the years of the independent foreclosure review, and so they have also done the same thing to people after that, which still could be in the 30%, but that's also a bank picked number, which is low because the bank's not going to pick a number that's high, and they tried to claim that it was 10% or less to keep in a guideline, which is another issue. It's the independent foreclosure review, or not review, but the settlement actually enabled and gave permission for the banks to still wrongfully take houses that were not in foreclosure up to 10%. It was legal.
Wait, they were not even in foreclosure.
Right, they weren't in default. They just took them, and they knew them. And the settlement allowed and approved that they could take up to 10% of the homes wrongfully. And then the banks had to admit, per the checks they sent out that are listed on the document that I handed you, that they had actually given checks out to 30% of the homeowners for unlawfully foreclosing that weren't in default. And that, again, is a bank number. And the reason I stress it's a bank number is because homeowners and lawyers and even Elizabeth Warren in one of her interviews says that that is a low number. It's most likely 50% to 80% of the homes that were taken and wrongfully foreclosed on without being in default. And that's okay, I guess, because the homeowner that's had the whole house stolen has gotten checks from anything from zero. I know many of them that haven't even received a check. $300, $600, $2,000, $600, and there are a few that are supposed to get $125,000. And there's a number out now, some information, an article stating that Russ Company actually misfigured, or I don't believe it's a misfigure. They actually didn't send out the right amount of checks knowingly, from what I understand from the article, that to 200,000 homeowners, they're being forced to reissue more money to the ones they did send. And when they issued it in such a form that it looks like it's junk mail. And then they made sure that even people I know of that sent in a new address saying, of course, we're not living there now, this is our new address. They purposely picked out a system that they would send it to the old addresses so that people wouldn't be getting their checks. They give them 90 days to cash it. They can't find the checks. Well, then, and there's no alternative for them to go in and argue that the checks are too little or to appeal it, or if it's 90 days, they may not be able to appeal it because they haven't cashed a check in 90 days.
So let's see, if you have just say, throwing a figure out there, $100,000 home, if you end up getting wrongfully foreclosed and the banks go, whoops, we're going to give you a check for your troubles, and they give you a $300 check
for taking your home away, making you homeless. People are sleeping in cars. People are doubling up in friends' garages. My neighbor has a friend living in the top of her garage. I had my daughter and son-in-law and 8 grandchildren living in my double car garage for a while, for 3 years over this.
For $300.
Wow.
$300.
That's amazing. It's terrible.
Yeah.
Isn't it terrible?
Yeah.
It's shocking. It's
shocking.
Absolutely, and this has been approved by, this number of $10 billion was set out there to make the public think that, oh, $10 billion is a lot of money. But when you divide it up per the people, it's nothing for what has happened to them.
Right.
And then to make that settlement, it was all unlawful. The settlement actually made 10% of the homes lawfully legal to be foreclosed on without being a default. But now they've breached the settlement because it's up to 30% per the bank admission. And I believe that Elizabeth Warren, Sherrod Brown, and Elijah Cummings are going to bring out the truth that it's probably closer to 50 to 80% of these homes were manufactured into default.
And you probably won't hear about it except for on this show because of the fact.
It could be because the media, well, the media's been slow, but there are articles coming out on the main media finally. After 5-6 years of this battle. You're seeing a little bit on the main media, but you're seeing most of the information on this show.
Right. I got to ask you, okay, I know that there are other issues when it comes to these foreclosures and Judge Peckman, and there's some laws that I think the judges are not taking into consideration. And one of these laws is the UITA, which is the Uniform Electronic Transfer Act. Now, I know that in the United States, across the United States, we have all 50 states have approved of this except for 3. Washington State is one of them. I believe Ohio is another. But the Uniform Electronic Transfer Act, Washington State has it. And Washington State, it's the RCW 19.34.320, I believe. And do you know what that says?
Yes, that says no digital message shall be deemed to be an instrument under the Title 62A RCW unless all parties to the transaction agree. You have to know that and approve. That, not just know and not have it written down so you don't know and you see something else going to MIRS. You have to know and explicitly agree that this can be electronically, digitally filed, because there's they did this somewhere around, they were trying to get it around 1995 to the year 2000, somewhere in there.
Majority of them was approved anywhere between 2005 to 2007 and 9.
Okay, so that was because I believe at the time with the S&L crimes, the saving and loans crimes, and some of our prosecutors putting over 1,000 people bankers in jail over this, that they were concerned about digital filing, that that it was too prone to become counterfeited, for the notes to be shredded, and they wanted people to explicitly know that there was a issue with that your notes could be shredded, your notes could be counterfeited, and that if you approved of this, then you were taking the chance of having happened what has happened. Right. All these counterfeit notes, these shredded notes, not knowing who owns your loan, the lenders, none of them seem to know who owns their loans. It's been admitted on video that you and I have viewed in the Senate. Senators have admitted to the senators that there are no original notes. No original notes. The lenders don't know who owned the loans. The assistant or the attorney for the state of Washington for the Title Association told the senators on a video that we have that
what did he say? If we had to all wait for original notes to be transferred over, nobody would be able to sell their homes.
Yes,
how does that happen?
He was actually looking at the senators and telling none of you will be able to ever sell your houses because there are no notes.
Well, that's an admission right there.
Yeah, who's to blame?
Yeah, that's right. It's not the
we didn't
homeowners.
Shred them.
Oh, really?
Right.
Yeah.
The homeowners didn't cause all this?
No, the homeowners. I mean, homeoers had nothing to do with this, and yet we're being blamed for it as homeowners.
And prosecuted. I mean, basically prosecuted because our houses are being stolen from us and literally manufactured.
You get $300. You get $300 for your house.
Yeah, we should be happy. And then I emailed a copy of my check. I actually got a $2,000 check. I lucked out. I mean, I've spent over $15,000 fighting in litigation, but I got a $2,000 check, and I actually copied my check, sent it to Huey, the assistant the assistant AG, and said, thanks a lot for nothing. And he said, well, you have the right to tear it up if you want to. That was his that was his answer back to me. You can tear it up if you want to.
Yeah, but
I'm supposed to appreciate this.
Yeah, in the meantime, you spent $15,000 in litigation just to be able to fight this sucker.
And it's still spending money. It hasn't ended. It has not ended.
See, what a lot of homeowners need to recognize is the fact that one of the reasons why UITA was put into place is because of the fact that because a lot of the lenders do not have the original promissory notes, and because they don't have the original promissory notes, they wanted to do things electronically because they wouldn't have to prove it. And so UITA was actually in place. It wasn't in place until, depending on the state, it was in place between 2005 to 2007. It's right around 3, 4, 5 years that all the states came in and approved us. Now, it just so happened that 3 states alone have not approved it, and specifically Washington State is one of them that has not approved it. But if the foreclosures and transfers were done prior to when your state enacted it, that means that it's no good. That means that, you cannot follow the law unless there's a law in place. If it was done prior to the enactment of the law, then the law, it doesn't follow the law because there was no law in fact. And these laws do not do what's called ex post facto. That means it does not take into effect prior to the date of an enactment. It starts from that date of enactment going forward. And so
I do want to be clear too that we do have a law that's in place of that. So that's why we didn't.
That's right.
We didn't accept the law.
Right.
We are covered by the RCW.
But
1934-320.
right, but
Yes.
the law reads that if I'm not mistaken, it says that unless all parties to the transactions agree. So basically, what you need to look at, homeowners need to look at the promissory note, and the promissory note is supposed to have verbiage in there that basically deals specifically with electronic transfers. And if you look at the promissory note, when you sign it, you agree to the electronic transfers. Now, not all promissory notes have that, because some promissory notes were signed prior to the enactment of the RCW and or prior to the enactment of the UETA law, right? And so it depends. It's a situation where maybe not, depending on what your contract says with the promissory note.
Oh, my promissory note was in 2005, and it has nothing on there stating anything.
If it doesn't,
to do with it.
right? The promissory note is a contract, and and you have to follow the terms of the contract.
Yes.
That's right. So if you did not agree to it,
what this law states is if this has not happened and this law hasn't been followed, that it's a void contract.
it's voidable.
Yeah.
It's void, not voidable. It's void.
Void have an issue.
It's void.
It's a void.
It is
very
void.
start.
It's not
Right.
voidable.
It's not
void.
voidable.
Yeah.
It's void.
Void.
Yeah.
Exactly.
Right. Exactly.
Yeah.
So
a lot of property owners and homeowners, do they really have a home that they own, or do they have a piece of paper that's toilet paper?
They have a piece of paper that's toilet paper, and they own their home actually by that law.
Yeah.
good luck in transferring the ownership of that toilet paper.
The judges don't have the right to be biased, and
Well-
they don't have the right to say, well, we
Oh.
don't want the homeowner to have a free home, or we don't. They also aren't supposed to be biased to say we don't want the bank to have a free home, but they're supposed to go by the rule of law, and there are
Really?
laws out there
What a
protecting the
concept.
homeowners, and they're not. They're blocking those laws.
Well,
Yeah,
and that's
yeah.
the thing.
Yeah.
The judges are there to uphold the law.
Yes,
they're not
exactly.
there to interpret, or not to change the law, but to uphold the law.
Yes.
Yeah, but aren't most of them have a mortgage holdings and securities, money interest in mortgages?
It's a very interesting thing. A lot of these
Yeah.
judges have investments, and they
Yeah,
have
yeah,
retirement
yeah.
funds,
That's
all
right,
wrapped up in the
securities.
banks and securities
Well,
and
then they're looking out for themselves, so they have a right to look out for themselves, but they have an obligation to uphold the law.
Can you say conflict of interest?
that's a conflict of interest.
They can't say that. That's not in their
They don't
vocabulary.
have the right to protect themselves if it's against the law. They have the right to protect
Oh.
themselves within the law.
But this is
when
America.
when they
Oh,
have
that's
an
right.
oath of office to protect their constituents, and they are biased for banks because it's protecting themselves, then that's a violation of the law.
Oh, wow.
Yeah.
Wow.
Imagine that concept. I think a lot of, like I said, I'm trying to be devil's advocate, okay? I would like to think that a lot of these judges are here to be an unbiased party.
I'm glad you like to think
I
that.
know, I would like to
I don't
think
believe
that.
that you're right.
I would like to think it, but I would like to think that these judges are an unbiased party, that we have two parties coming in, and they're to be Solomon and to divide the child in half.
That's the
But
way it should be,
that's,
Janet.
That's the way, but I'm
Yeah.
fine. Are you seeing that it's not that way?
No, I'm not. If I did, would it make any sense that the banks admit on a piece of paper that they've unlawfully foreclosed on 30% of the houses just in those 2 years period of 2010 and 2011 without them being default, and make sense that the judges keep dismissing these cases? And as far as I know, there hasn't been one case with Peckman that I have found that judges for the homeowners have. There should have been at least 30% of her cases, and I believe that's a low number. So with all of these houses being dismissed and all these foreclosures being done, they had to have the help of the judges, because people, who do they look towards? They look towards the lawyer. They look towards the judges for justice, and justice has not been done, which is, to me, showing that these judges are not ruling by the rule of law. They are ruling by bankroll and
That's right.
unconstitutional law.
Okay. Well, getting back to what happened with Judge Peckman, I got to ask you, what was your reaction when they decided to interview you?
Well, I kind of felt with my attorney warning me to cut back a little bit, that I might see him, but I really didn't think I would. So when they came, I wasn't totally surprised, but it was still kind of shocking. And I don't, I just don't feel that it's that big of an issue. But I can see their concern too, that a judge that would have a huge list of a lot of people that dislike her, and a lot of homeowners, because there are a lot of homeowners, I'm sure, that that have been harmed by judges blocking justice. That a lot of them would flip out, or some of them would flip out. Hopefully they won't, and they won't do anything crazy. So I can see that why they would need to go and investigate and make sure that nobody's going to harm a judge, because nobody has a right to harm another human being for any reason.
Well, interestingly enough, I was watching YouTube, and there was a gentleman named John Kohler who has a show called Growing Your Greens. And apparently while he was gone, his house is in California, while he was gone, his home was searched by the police. I think it was the U.S. Marshals. They went in and searched him.
Which is exactly what came to see me.
Right, and they searched him because his neighbors said that he had grow lights, and they were afraid that he was growing marijuana. So here is the question that I have. You know, when you have a situation where you're talking things about judges, and not just judges, but all sorts of things on your blog. He's growing vegetable starts in his bathroom. And all of a sudden, we have policemen coming in, talking to you, U.S. Marshals coming in, talking to you, U.S. Marshals talking to him, searching the houses. My question is, have we become a police state?
I believe that we have. I think we've been a police state for a long time. It's just becoming more and more obvious that we're a police state. I have seen too many things, even within my own neighborhood, that are very shocking and scary. And it is scary. I mean, it was frightening in a sense that you're wondering, okay, are they coming for you because of this judge situation, because you know about it on the internet? Or are they coming because I'm advocating against the crimes against homeowners? I feel like we've lost a lot of our rights. And then you hear about the FEMA camps, so you wonder, okay, am I going to be the first one handcuffed and driven to a FEMA camp?
Well, you know,
yeah, it was a bit terrifying for that reason.
There's FEMA camps all across the United States. The largest FEMA camp is in Alaska, and it houses, what, 2 million people?
Actually, you'd be surprised. There are 3 more that are supposed to be larger than that in Alaska that I personally know of a contractor that was invited to go there and build, and they are done now. So that hasn't been out in the public or hasn't been on the web. At least I haven't looked it up. But at the time, the one in Alaska held over 2 million people, which, why? And they're empty. What is that for? But a contractor I know was, 2 contractors I know were invited to go up there and work on them. And once I exposed to them what these FEMA camps were all about, they refused to go up there and work on them. And friends of theirs say that they are completed now, and they thought they were actually going to use these camps a year ago, just before the elections, but they haven't used them yet. So what are they for? And these are bigger than the original one that was over 2 million people in Alaska. So that's scary. That's very scary.
Well, thank you so much, Shelley. You've been so wonderful in talking with us, and I appreciate your wisdom and intelligence and everything else. And I hope your conversation today has been informative, educational, inspirational for your life. If you wish to join our show or to help investigate, educate, and disseminate any information about the foreclosures, mortgage, fraud, government, or any type of misuse or any other issues, please contact us at info@mirsnow.com. And I hope to see you again next time, and thank you so much for joining us. Thank you. Bye-bye. It did. It goes quick with every time.